Increasing number of civil society groups and left of centre thinking people across Europe that both TTIP and CETA may very well be instruments to override democracy. And we could therefore be about to embark on the most aggressive phase of capitalism, where firstly, regulations originally put in place to protect the best interests of consumers will either be weakened considerably or discarded on the basis that they are an impediment or a barrier to trade. And secondly, an investor-state dispute settlement mechanism will be utilised to protect the interests of international investors, and whereby they can sue individual states through a panel of arbitrators set up by and for themselves and of themselves, should they believe that the state is operating contrary to the investor's best interests. That to me now is a fair description of an investor's paradise. And at this stage I think I should make it clear that ICTU is not opposed to international trade. We're an open economy and we depend on quality, fair trade. ICTU at its biennial delegate conference recently resolved to oppose TTIP and CETA. And now this agreement is now awaiting the completion of the process through the European Parliament. And the TUC, our sister organisation in the UK, last week handed a citizens' petition to MEPs seeking their rejection of this trade agreement. There is an expectation that the decision on CETA in Europe will be made early in 2016. However, I understand it needs to be translated into the languages of the 28 member countries, and it also needs to be reviewed by the legal teams. I think, though, it's just on that point, it's worth noting that the European Commission is still awaiting the outcome of the ECJ judgment relating to the Singapore Agreement signed in 2004 to clarify which elements fall within the EU competency alone and which remain within the remit of member states. Now, this judgment I think will be a very important one in terms of underpinning the necessity for member states' parliaments to approve these agreements. One would expect that CETA also would have to be ratified by the 10 Canadian provincial legislatures. For purpose of this debate, our analysis is assisted by the fact that the text of the CETA trade agreement is agreed between the parties and published. And in that regard, I want to concentrate on just a few specific elements, which really, for me, paint the picture of what this agreement is about and what actually the consequences of it would be. In its preamble, the agreement states that the parties resolve to create an expanded and secure market for their goods and services through the reduction or elimination of barriers to trade and investment. Establish clear, transparent and predictable, mutually advantageous rules to govern their trade and investment. And finally, recognising that the protection of investments and investors with respect to their investments stimulates mutually beneficial business activity. That's a fair preamble now to tell you what this is about. Okay? Fairly stark and written in fairly stark terms. So then I looked at section 2 of the agreement, which refers to establishment of investments, market access. And it opens up with the line, neither party shall adopt or maintain with regard to market access measures that impose limitations. For example, the number of enterprises that can carry on economic transactions, the value of the transactions, the value of the assets. And there shall be no requirements to export a given level of good or services, or to achieve, and this is really important, or to achieve a given level or percentage of domestic content. This effectively, and the list is a lot longer than I read out to you, and anybody who's an interest in it, I would suggest they go and have a look at it. And this effectively, in my judgment, gives free rein to the operations of investors. It's a scary piece. It's on pages 153 to 154 of the agreement, and I think anybody who's interested in it should have a look to get the full picture. It then goes on to expand on investors' rights to compensation in the event of breach of the agreement by either party, and it outlines in great detail the terms of the ISDS. So, I think it was important that I looked at it in detail, and I did so just to ensure that I understood precisely what it was they had written in the agreement and to see was it any different than the commentary we've had without access to the actual written agreement. So, the agreement states that an investor may submit to arbitration a claim that the respondent has breached an obligation under the agreement with respect to, wait for this list, they can make a claim for compensation with respect to, if they feel there has been a breach, the expansion, the conduct, the operation, the management, the maintenance, the use, the enjoyment, the sale or disposal of its coveted investment. Basically, they have covered everything. There's not a lot left out of that list. So effectively what they've given themselves is the right to make compensation claims on basically any matter relating to an investment, where the investor claims to have suffered loss or damage as a result of the alleged breach. They then, and I have shortened this obviously, they say it will be a consultation for 60 days between the disputing parties. If the objection comes from Canada, the hearing will be in Ottawa. If the objection comes from Europe, it will be in Brussels. They then have a mediation process that can be utilised before it goes to arbitration. And then the parties can agree to have sole arbitration, but if they don't do that, they can have a tribunal. And the tribunal is made up of one party each appointed by the dispute parties and one presiding arbitrator. 3 international lawyers. And then they say, and they say this in the agreement, all 3 arbitrators will be independent. The next heading they have is transparency of proceedings. So that looked interesting, so I went and looked at this. And they say that they will apply the UNISTRAL rules on transparency, which were put together in 1958. And this means that the notification to the parties on consultation and mediation and determinations, notice of challenge, will be included in the list of documents subject to redaction of confidential or protected information. So when they say they'll give information, what they'll give is a list of the basic pre-notice documents associated with the piece. You won't garner a lot of information from it, but that's what they give you. Now, I went and I had a look at this term, confidential or protected information, because this is really important in this. And it means, in their terms, confidential business information which is protected against being made available to the public under any law or rule as determined to be applicable to the disclosure of such information by this tribunal. Now, I regard that now as transparency at its best. Right? So they'll go into a room and they'll tell you under this definition of confidential and protected, which they made up themselves, and they have, it's in the agreement, they've made it up themselves. They'll put that in, and these arbitrators, independent, will decide all of this. They then go on to say, and the reason I'm highlighting this is because when the machine starts to get going in 2016 on this, by the machine I mean the people with the deep pockets who want this to go through, the thing they want to come out and say is these hearings will be in public. That's written in the agreement. That's the reason I'm going into this detail. That's written in the agreement. And what they say is the hearings will be in public, and the tribunal will determine, in consultation with the disputing parties, the appropriate logistical arrangements to facilitate public access to such hearings. Where the tribunal, this is the catch, where the tribunal determines that there is a need to protect confidential or protected information, it shall make arrangements to hold in private that part of the hearing requiring such protection. This arbitration is binding. So what does that mean? The definition I gave you about confidential and protected information means you hear nothing. There's no public hearing. Because you'll walk in and they'll say, we can't let you hear that. This is protected confidential information under their definition. So, having considered all of this detail, I believe it is not excessive to claim that despite the claims of transparency and being open to the public, the ISDS system is an affront to democracy. The open to the public claim is, in my view, very misleading and without much foundation. Effectively what they mean is that they will decide under their own rules what will be published, and given the description as outlined, I don't think we'll be overburdened with meaningful information. In fact, they would be more upright and honest if they declared that the hearings are closed except in respect of generalist information. In democratic societies, uniform application of the law is a foundation principle, and rather than undermine this principle, we should advocate that international investors comply with domestic regulation, even though this is not always in the interests of free-range capitalism. Under the ISDS system, states maintain the right to regulate, but this right may be severely restricted if it is measured against the overall priority of reducing trade barriers and the threat of large payment of public monies to transnational corporations. And that's the freeze effect that can occur in this, or the chill effect some people refer to it as. An increasing number of countries are rejecting ISDS in their trade agreements. Australia insists that ISDS mechanisms were excluded from the trade agreements they negotiated with the US in 2005. And in 2013, South Africa cancelled a number of bilateral investment treaties, partly due to the dangers of ISDS. And earlier this year, Indonesia announced that it would be terminating more than 60 bilateral investment treaties due to concerns about the threat ISDS posed to its public policies. Inequality lies at the very foundation of ISDS as it privileges foreign investors over economic actors, domestic investors or interest groups such as consumers or workers, by giving them the right to special courts to pursue the rights of expropriation. There are a number of alternative protections for investors that could be built into trade agreements and could be used instead of ISDS. And the ETUC resolution on EU investment policy calls for state-to-state mechanisms to be used for restoring dealing with and resolving disputes, as well as a requirement that domestic courts are used by investors filing claims against states. In the final section I want to look at on trade and labour, and that's dealt with in the agreement under Chapter 24. And the agreement includes phrases such as, the parties recognise the value of social dialogue in labour market matters among workers and employers and government, and commit to the protection of such dialogue. The parties recognise the right of each other to pass its own labour laws. That's big of them. And the parties recognise ILO conventions and commit to maintaining a system of labour inspectorates and encourage public debate, promote awareness of labour law, and consider any views of workers or citizens. Now, then comes the really important phrase. Each party to the agreement will make sure that these provisions are not unnecessarily complex or prohibitively costly. And that phrase tells us what they really mean. So, how would they go about implementing those fine principles? Well, here's what they say in the agreement. They say each party will set up a contact office of advisory groups. Social party and civil society groups will meet once a year. A party may request consultation on matters of labour. A panel of experts can be established, made up of international labour lawyers, to hear the request and examine the matter. The panel can liaise with the ILO. The panel can make a determination. And guess what? When they make the determination, this can be monitored and sent back to that advisory group that meets once a year. Now, you do a lot with that if you had a labour issue. So that process underpins the fact no sanctions if labour rights are violated, no compensation tribunal to award workers for losses, just a mere opinion from a group of lawyers which will be looked at once a year. There are many more matters of concern to us, including the environmental and deregulation measures aimed at removing non-tariff barriers, but ultimately leading to a lowering of standards for consumers. In summary, the concern of ICTU is that these agreements are a manifestation of an aggressive neoliberalism with an overwhelming emphasis on competition, privatisation and structural reform, all of which serve to undermine the European social model. If you have free trade, free circulation of capital and people, and destroy the social state, then the temptations of the defensive nationalisation and identity politics starts to grow, and we are seeing some of that growing across Europe as we speak. The main emphasis in this trade agreement, as I have outlined, is to promote and protect and compensate investors. That is the bottom line running as a thread right throughout this agreement. They get secretive and special mechanisms to claim their rights, but the agreement confers no such rights on citizens, consumers or workers. No courts or sanctions to those who violate international labour standards, product safety or environmental protections. Corporate interests get all the rights, opportunities and protection and indeed compensation without any accountability or responsibilities for their actions. So let us be clear. If CETA is voted through, it will make it easier for deals such as TTIP to further weaken workers' rights and threaten democratic decision making. This agreement is nothing other than a blueprint for the expansion of rampant capitalism at the expense of consumers, citizens and workers. No wonder investment in Europe is sluggish. They're awaiting the investor's paradise. Thank you very much for listening to me.